Did you have in your possession cocaine?
Yes, Your Honor.
Had you used it?
Previously, yes, Your Honor.
And did you know what you were using was cocaine? Yes, to you too, sir. Court calls the case, People versus Amanda James.
For the people, Your Honor.
Assistant Public Defender Zach Van Withen on behalf of Miss James, who approaches. James, please state your name for the record.
Amanda James.
Your Honor, this is the date and time set for a bond violation, as well as potentially a plea. Your Honor, Ms. James would admit to the violation of testing positive for cocaine on June 11th, and then she would ask for an immediate sentencing. She has been in custody ever since then, so she's done 3 weeks. So she would ask for a sentence of time served. And then, Your Honor, I believe that if Your Honor were to accept that admission, we would be prepared to plea today.
Do I have paperwork on the plate?
We did submit it previously, Your Honor. I guess if it's not, I guess we can get it refiled if not.
I see it. Oops. I'll accept the admission to the violation. Anything you want to say before I send? How long has she been in?
She's been in for 21 days, Your Honor. Ms. James would be requesting a sentence of time served. She indicates that she would
21 day credit time served.
Your Honor.
It is about me. Yes. May I have her sworn?
Raise it right here. You solemnly swear to affirm the testimony you're about to give, nothing but the truth, sir.
Yes, I do.
State your name.
Thank you, James.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. Then the plea form indicates that that's an added count 3, so counts 1 and 2 would be dismissed.
Excuse me.
Understanding that you still wish to plead guilty. I'm sorry if I asked you.
Yes, Your Honor.
All right. To that charge, how do you plead?
I plead guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir. Yes, Your Honor.
You signed an advice of rights form previously, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of the trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
Yes.
Which one?
Probation.
Were you on probation at the time of this offense?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
April 25th, 2025. Location of 2201 Hogback, Washington County Jail.
This one's a strange twist. A cocaine possession charge, but the location inside the county jail itself. Drug use isn't stopping just because someone's already locked up.
Did you have in your possession cocaine?
Yes, Your Honor.
Had you used it?
Previously, yes, Your Honor.
And did you know what you were using was cocaine?
Yes, Your Honor.
Ma'am, I accept your between the time of my acceptance of your plea and the time of sentencing. If you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other threats or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule?
The defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be
July 22nd at 9 a.m.
July 22nd, 2026, 9 a.m. before me. Her bond be reinstated to her incarceration with those same terms. You understand that, ma'am?
Thank you, Your Honor.
Thank you. Don't mess it up this time. Gonna mess it up, we might as well just leave you.
Thank you, Your Honor.
People against Mark David Wicker. Mark David Wicker, 267-842-655, A, B, and C. 249, right? Morning, Mr. Salas, your appearance.
Good morning. And please the court Nicholas South, P3470 for Mr. Linder, who's against my right.
Did you call him?
I call. I told
Your name.
Mark Woodward.
So, Mr. Yurick, your name.
William Derrick, I'm going to have the city of Woodhaven, Your Honor.
So he's got a .074.
Correct.
The legal limit for operating while intoxicated is .08, right?
Correct.
You can tell these guys not to write these if you're not going to prosecute them. You know what I'm saying? If they're not going to, if they're going to write guys for with an .074 and you're going to come in and dismiss them or reduce them like this, maybe they shouldn't write them. You follow me? I'm just telling. Are you offering this attempt to operating while impaired because you think you have a difficulty proving your case?
I'm offering the attempt based upon some of the equities that brother counsel brought up.
Like what?
Up to and including the young man's employment, where he is employed.
Where's he employed? Everybody thinks their employment's important.
St. George Orthodox Church, Your Honor.
Doing what?
He's been there 18 years.
Doing what?
In a catering facility, managing the grounds. Is it a technical job? No, but he's always on time. He's well liked.
Okay, I get it. But everybody has jobs. I need something more than that. Are you telling me you have difficulty you feel proving your case?
I am not.
You're not saying that?
I believe that the stop is valid, and I believe that the proposed jury instruction were there to be one.
Okay, so let me so here's my issue. I have difficulty reducing drunk drivers. I try to never get my nose stuck into what you guys do, but that one is something else to me. Now, this stuff about working as a caterer doesn't hold water to me. I don't care if he's a caterer. I don't care if he's a doctor. I don't care what he does.
Now watch a judge push back on his own prosecutor. An OWI is being reduced to an attempt charge, and the judge is making it very clear he's not thrilled about this deal.
So let's take that out of the equation. If you can't tell me you got problems with your case, I don't want to take the plea. If you got problems with your case, that's a different story. But if you think you can prove this case, I don't know why you're giving him a better deal than anybody else gets. No, and I'm serious. I'm not trying to get on you. I'm trying to tell you how I feel. I think I've told you in other cases how I feel about these. And if again, I'm going to repeat what I said. If there's a problem with the case, you're duty bound as a prosecutor to treat people differently, dismiss cases if you can't prove them. You're duty bound, really, if you think you have a problem with the case, to not necessarily roll the dice. But I don't want to hear this stuff about he's a caterer. I get so tired of hearing about people's employment. Like, big deal. I'm sorry what to say. It's like commercial drivers. I got lawyers. Oh, well, he's going to lose. Well, maybe he should have thought about that before he got behind the wheel after being drunk. But now I want to hear from you.
No.
Go from there.
Understood, Your Honor, and the employment was simply top of mind due to the fact that I think maybe for the first time in my tenure here, I read a letter of reference from his employer, the Monsignor of the parish. But notwithstanding that, there was a failure to provide the second intoxilizer sample. So there is that evidentiary feature, if you will.
They didn't provide him with, they didn't give him a
One
second.
sample, one good capture, the second one was a fail.
So
That's the intoxilizer.
So that's an issue, right? All right. You want to write it down for me?
Sure.
So I just want to be clear. Is there something about the level of the breathalyzer here that's causing you to do this? I mean, you didn't have a 2-0.
Correct.
It's harder to prove an 074 case, right?
It is harder to prove an 074 case than
By a lot, right?
an 08 case. And most of what we see, Your Honor, is the low to mid to upper teens, and then
I haven't taken an attempted operating while impaired. I think he's still going to lose his license.
It is still a drinking offense.
I know that, but I think he's still, I don't know how many points they're going to assess. I would think 4, but I would think that this, pardon?
I believe that's correct, Joe.
But I think that he's going to get suspended, but I think the possible penalties are only going to be up to 150 fines, 45 days jail, 180 hours community service, court costs are all. I don't know if the community service would be less, and I'll figure that out, but I don't know that that's really an issue. And I just want to be clear. So that's in part why you're doing it, correct? Because I don't want to hear about people's employment anymore. I'm so tired of hearing about people's employment. I want to be, you understand what I'm saying, Mr. Urick?
I do.
I hear that all the time. Everybody thinks they're special. I don't care if he's working at a church. I don't care where he's working. Do you understand what I'm saying to you, sir? So I'm going to take your plea. If you plead guilty to operating while, attempted operating while impaired, I'm going to dismiss the operating while intoxicated. The possible penalties are going to be, I believe, up to 150 fines, 45 days jail, costs are all those. Do you understand that? I can't hear a word you're saying. Yes?
That's right.
And you understand it's a 4 points. Did he sign an advice of rights form today?
2 weeks ago. Your Honor.
No. What rule says I can rely on one 2 weeks ago? Come on, guys, you got to help me in. He's got to sign the form. The court rule is abundantly clear. I either have to advise him of his rights or he has to sign one when he's taken a plea. Sign one on the initial appearance and then sign one when he's taken a plea, or I got to go through these verbally every time. So, so they only charged operating while visibly impaired.
Correct.
Okay. Good enough. You understand everything here, Mr. Wicker? I want you to take the time reading that advice of us. Was this a young officer that wrote this? I don't want you to mention his name. I mean, you get what I'm saying, though. If they're going to be behind, I mean,
Your Honor, can I want to thank the prosecutor.
you can thank the prosecutor for, but do that later. Just have him sign the advice of rights. I'm taking my plea. Quit while you're ahead. Right?
Absolutely.
All right. You understand those rights, sir? Did you sign those? Did you read that?
Yes.
You understand if you plead guilty, you're giving up the presumption of innocence, you're waiving the requirement that the people prove you guilty beyond a reasonable doubt, and you're waiving all your trial rights. You're waiving your right to a jury trial. Do you understand that?
Yes.
All right. If you plead guilty, we are not going to have a trial. You're giving up all of those rights, and you understand that. All right. And you understand if you plead guilty to operating while visibly or attempted operating while visibly impaired, I'm going to dismiss the operating while visibly impaired. They did not charge you with drunk driving because the level of the breathalyzer and the possible penalties again on that are up to 150 fines, 45 days jail, 360 hours or 180 hours community service, costs are all, and they still believe 4 points would be added to your traffic record and your license would be suspended or revoked in accordance with that record. Do you understand that? And is he also pleading to expired plate? Is that what's going on? And then the no proof is being dismissed? And you understand if you plead to that, I'm going to also dismiss the no proof of insurance, right? All right, just keep your voice up for me, will you please? All right. To the charge of attempted operating while visibly impaired, how do you plead? Nice and loud, please. Speaking to that microphone, it might help you. You're soft-spoken. The charge expired plate. Do you plead responsible or not responsible? Were you operating a motor vehicle on Western, Holland, Woodhaven on April 28 or 26 at 12:38 in the morning? Prior to that, did you drink alcohol? And if so, what did you drink and how much?
I didn't know.
Hang on, Steve. Hang on. Keep your voice up. I can't hear you. I'm not gonna, come on. Help me out. Speak into that. Get closer to that. What did you drink on that date and how much before you operated the vehicle?
2 shots, sorry.
2 shots of what?
Yeah.
Okay. And then you operated the vehicle.
Yes.
Do you know why you were pulled over by the police?
No insurance and the rest.
Yeah, I know, but did they see something? Were you speeding, weaving, running stop signs? What were you doing?
I was driving home, sir.
What?
I was driving home.
All right, so you don't think you did anything wrong in the operation of the vehicle then? I mean, you were drinking, I get it, but you don't think you were pulled over because you were speeding, any of that?
I wasn't speeding, no, sir.
All right, but you had an expired plate at the time, correct?
Yes.
All right, and the breathalyzer result, this was an intoxilizer, correct? Correct. And you stipulate, Mr. Salas, that the result was 0.074 for purposes of the plea?
Yes, sir.
All right, and are you on probation or parole, sir?
No,
Anybody force you to plead guilty?
no.
Okay, and again, let's see, what did I do with that now? To the charge expired plate, how do you plead responsible or not responsible?
No.
All right, I'll accept the plea to attempted operating while impaired. I'm going to dismiss the no insurance, dismiss the operating while impaired. And I'm also going to dismiss the no proof of insurance, okay? Now. All right, Heather, I hope you got that. This one's a little different. I'm dismissing the operating while impaired, accepting the plea to attempted operating while impaired, accepting the plea to expired plate pursuant to the agreement, dismissing the no proof insurance. Again, the original charge that was not drunk driving of operating while impaired will be dismissed. I'm still going to order a screening and assessment. You're going to come back later. Heather, why don't you give me a date?
How far out do you want to do this one, Judge?
How many do we have for the 10th of June? If we have
Right now, we have 3 sentencings at 8:30.
let's do this. Can you do this at 8:30 on the 10th?
This is 9:30 on the 10th?
As long as you're here by 9:30. How's that?
Okay.
Okay, I just get screwed up when guys show up later and they're starting dockets. 9:35, but just be ready to go. He's gonna go down the hall,
Yes.
and I'm deferring the sentencing on the expired plate, by the way, Heather. And I'm dismissing the no proof. For the record, what?
Did you say 9:30 for this, Judge?
Yeah, 9:30. Mr. Salas wants to sleep in a little bit. Just kidding.
So far,
Go ahead.
he does have proof with him of the English plate and getting the insurance.
Good. Remind me of that at sentencing. Okay? Thank you. All right. So go down the hall with him. He'll get the notice and we'll see you back here. Have a good day.
The judge eventually signs off on the deal, but not without making his frustration crystal clear on the record. Stick around for more courtroom clashes like this one.